La Cour.
Please be seated. I declare open the public hearing on the merits in the case of Chiragov and others against Armenia. The application was lodged with the court on the 6th of April 2005 under Article 34 of the Convention by 6 Azerbaijani nationals, Mr. Elkan Chiragov, Mr. Adishirin Chiragov, Mr. Ramis Gebrailyov, Mr. Akif Hasanov, Mr. Fekeredin Pashayev, and Mr. Kwaraka Gabrailov. The application was allocated to the third section of the court pursuant to Rule 52, paragraph 1 of the Rules of the Court. It was communicated to the government on the 8th of June 2006. On the 9th of March 2010, the Chamber decided to relinquish jurisdiction in favor of the Grand Chamber. The application was declared admissible by the Grand Chamber on the 14th of December 2011. The respondent government are represented by their agent, Mr. Gevo Konstantian, assisted by Mr. Emil Babayan, Deputy Prosecutor General of Armenia, and by Mr. Jeffrey Robertson, QC, and Mr. Toby Collis, advisors. The applicants are represented by Mr. Mark Miller, QC, Mr. Sudhanshu Swarup, Mr. Michael Ivers, and Ms. Michelle Butler, counsel assisted by Ms. Catriona Vine, Mr. Brioni Poinor, Mr. Kerim Yildiz, Ms. Saina Karakas, and Ms. Angela Evans, advisors. Two of the applicants, Mr. Akif Hasanov and Mr. Fekeredin Pashayev, are also present. The applicants being of Azerbaijani nationality, the government of Azerbaijan have expressed the wish to take part in the written and oral proceedings as a third party in conformity with Article 36, paragraph 1 of the Convention. They are represented by their agent, Mr. Cengiz Asgarov, assisted by Mr. Malcolm Shaw, QC, Mr. Gabriel Lansky, Mr. Otarik Vazaldze, Mr. Hannes Tretter, Ms. Tatiana Urdaneta Vitek, and Mr. Orkan Ismailov, advisor. I welcome the representatives in the name of the court. I also welcome delegations from the Turkish High Council of Judges and Prosecutors. Having consulted the agents of the governments and the representatives of the applicants, I have determined the order of addresses as follows. Mr. Miller QC for the applicants will speak first, then Mr. Kostayan for the Armenian government, and finally Mr. Asgarov for the third-party government. I would explain that in addition to interpreting in the two official languages of the court, English and French, interpreting into Turkish has been authorized for the benefit of the group of Turkish judges and prosecutors. That interpreting is not arranged by the court, and no transcription of the oral translation will be included in the official record of the proceedings. I call Mr. Müller QC.
Mr. President, this case concerns an application by 6 Azeri Kurds who were forced to leave their homes in Lachin in Nagorno-Karabakh after it came under attack and was ethnically annexed by Armenian-backed forces on the 18th of May 1992. They have been prevented from returning ever since, and therefore they complain that the loss of control over their property constitutes continuing violations by Armenia of Article 1, Protocol 1 and Article 8. As the Court rightly noted in its judgment of 2011, it does not appear to be in dispute that the applicants had no access to their alleged homes and property since May of 1992. Rather, the most contentious issues appear to be the exhaustion of domestic remedies and whether the respondent exercised overall control over Nagorno-Karabakh through a subordinate administration. Mr. President, I will address you on exhaustion, Mr. Swarup on effective control, Mr. Ivers on the merits, including victim status, while Michelle Butler stands ready to help with replies. But let me, first of all, say a few words about what this case is and is not about. We say this case is about impunity, the potential opening up of a human rights lacuna within convention machinery, and whether this court is able to protect the rights of the most disadvantaged in our society during times of conflict and political transition. For there can be no more disadvantaged category of persons than that of IDPs who have been forcibly removed from their land and their lives for the better part of 2 decades. They have been condemned to a transitory shantytown existence with no hope of a better life other than through this court. Theirs is a fate that the people of Armenia know about all too well, and it is one that Armenia rightly reminds the world should never befall a minority population in Europe again. It is important to note, however, that while this case may have profound consequences for the integrity of the European public order, it does not raise any novel points of law. The respondents submit that the effective control implies, and I quote, detailed direction or control over specific operations of the controlled entity. But there is no basis for departing from the settled case law of the court. The attempt to apply a different legal test legally obfuscates matters and detracts from the factual task at hand. The applicant's primary case on jurisdiction is that Armenia exercises overall control over the Nagorno-Karabakh through a subordinate local administration, as per Alascu. It is therefore not necessary to show that Armenia controls every action in the NKR in detail. This is entirely a question of fact, not law. And in this regard, the Court should note the respondent's persistent failure to engage with either the applicant or the Court's question on effective control. Take, for example, the following unrebutted admission. In December 1989, the Armenian government declared to the world Nagorno-Karabakh to be an enclave, to be part of a unified Armenian Republic. I do not need to remind this court what then transpired. Yet on the 9th of June 2006, in a reply to a question of the Third Chamber concerning remedies, the respondent declared, the government of the Republic of Armenia insists that the territory in question, particularly Nagorno-Karabakh and the surrounding territories, are not under the jurisdiction and control of Armenia. How is the court to reconcile these two statements? Did a radical shift of policy occur in which Armenia gave up its historical claim over the territory? Or do these statements form part of a consistent policy? We say Armenia achieved its dream of a unified republic through the occupation of Nagorno-Karabakh, but thereafter crafted a subordinate separatist state to which it now denies legal, if not political, responsibility for its acts. How else are we to explain the startling admission of the Armenian Defence Minister in October 2000, and I quote, that the public declarations that the ARA took no part in the war were purely for foreign consumption? The failure to rebut these admissions, in conjunction with the unrebutted presumptions of fact in favour of the applicants, creates strong, clear and concordant inferences that eviscerate the respondent's claim that the NKR is a wholly independent state. Mr. Swarup will take the court through the other pillars that demonstrate overall control. But even if one was to apply a more detailed test, the applicants would still be able to demonstrate the respondent exercised detailed control over the NKR's policy towards Azeri IDPs, from the respondents' preventative policy towards their return, to the failed submission of the NKR legislature extinguishing property rights of the applicants in 1998, onto the 2012 new claim that the applicants were always at liberty to enter Armenia and Nagorno-Karabakh to file claims. Indeed, far from establishing legal independence, the recently filed party pre-evidence of NKR officials merely demonstrates how easy it is for the respondent to subordinate those officials to its policy and legal needs, as and when it needs to do so. One need look no further than in the admission of Armenian IDPs from Syria into Nagorno-Karabakh after Armenia decided to take them in, to find compelling evidence of the respondents' control over the return of IDPs to that territory. Let me then turn to the issue of exhaustion. The applicants say there were no identifiable remedies, let alone effective ones, to exhaust when they lodged their application. As Aktavar and Alusky make clear, the applicant is only obliged to have recourse to remedies that are both accessible and effective. Where a government alleges that the applicant has not exhausted domestic remedies, the burden falls upon it to prove that the remedy in question was an effective, available one, capable of providing redress and which offered reasonable prospects of success. Regard must also be had to the circumstances of the legal and political environment and the applicants. On the 9th of June, the third section asked this question: what remedies were or are still available to the applicants, and would these remedies be effective? In response, the respondent failed to identify any remedies, and for 7 years wrongly asserted that it was for the applicant to prove a negative. This is a fundamental error of law and is demonstrative of the respondent's misconceived approach to the entire question of remedies. As early as the 27th of February 2007, the applicants made clear that the government bore the burden of proof, that an administrative practice existed, and asked the court to note the ethnicity of alleged returnees. The respondent replied by citing several cases where people of Kurdish and Azeri nationality had applied to the respondent courts. However, none of these cases relate to the right to the return or the use of enjoyment of property. At no stage either did the applicants claim that they were free to enter to pursue their rights. In fact, at paragraph 26 and 33 of those submissions, it said, firstly, it was not prepared to recognise the claims of displaced people until a comprehensive final solution was agreed, including those of the applicants, and that the IDP issues had already been submitted to the OSCE. Both these points were repeated in May 2010 and therefore represent settled policy. We say this evidence, read together with the OSCE and UN resolutions and other reports, demonstrates as a matter of official Armenian policy that the applicants are not permitted or able to permanently return to their homes. This refusal reflects an acknowledged official policy which amounts to administrative practice rendering any remedies theoretically available to them ineffective. Indeed, many of the international reports relied upon are not only well researched, but prepared by reputable bodies with access to intelligence. The fact that the contents are not denied, but merely described as hearsay, speaks volumes. Moreover, the territory from which the applicants were driven out remains a conflict zone. It follows that without an internationally recognised right of return, any claim the applicants could have lodged in the courts of Armenia or Nagorno-Karabakh was bound to fail. Thus, even if the respondents had identified an appropriate remedy, the prospects of reasonable success would have been minimal. Before 2012, the respondents asserted that the applicants' property rights had been extinguished by the enactment of local NKR laws.